All right, the next case on the morning's docket is case number 22697, Legends Golf versus LGCC Holdings. All right, again, welcome. It's 20 minutes per side. Appellant can reserve as much of that time as you'd like for rebuttal. I'll set it at 5 minutes. If you want anything other than that, please just let me know. And if you are ready, you may proceed.
May it please the court. My name is Scott Stengel, and I represent the appellants Legends Golf Orlando LLC, Miguel Vidal, and LTSC US Services LLC, trustee of trust number 1608KD, dated May 1st, 2001. I'd like to reserve 5 minutes of my time for rebuttal. We are asking the court today to overturn the final judgments as to the counts 1 through 4 entered against the appellants and remand for a new trial based on clear due process violations. Throughout the course of this action, the trial court allowed the appellees to proceed by trial by ambush. The appellants were repeatedly denied adequate notice and a meaningful opportunity to be heard, resulting in a violation of the appellant's fundamental due process rights.
Counsel, I've spent a lot of time with the record going through the events of the case, and what's troubling me is that everything could have been prevented if your clients had gotten new counsel when they were supposed to under the trial court order within 30 days. So didn't they assume the risk of everything that happened afterwards?
Well, respectfully, I would disagree that everything could have been prevented because the trial was originally noticed to take place in person on May 7th at the Lake County Courthouse. On 6:45, the night before the trial, May 6th, an email is sent out to some of the parties, appellee's counsel, one of their witnesses, and appellant Miguel Vidal. It was not provided to any of the other appellants, specifically the trust and Legends Golf Orlando LLC. So there is no way they could have known to appear or could have been able to appear.
They can only appear through counsel. They're not allowed to represent themselves, and the trial judge entered a specific order that your clients ignored.
Well, respectfully, I would disagree that they ignored it. There's evidence in the record that they attempted to obtain new counsel. This trial order was entered the trial order, a minute trial order was entered in March of 2019.
The trial court gave them 30 days. You don't
yes, Your Honor.
Why isn't that sufficient time?
Well, Your Honor, you have to remember the events that were going on in the country at that time. The order allowing the appellant's prior counsel withdrawal was in the beginning of, I believe, April 3rd of 2019. In between that period of time and when the trial took place on May 7th, the COVID-19 pandemic came, really hit this country hard, resulted in courthouses being closed, businesses closing, Governor DeSantis issuing a moratorium preventing
affidavits that set all that out.
Yes, Your Honor. There was an affidavit that was filed in support of the motion for rehearing and the motion to vacate by Miguel Vidal that testified as to the efforts that he took to obtain new counsel and that he had difficulty because a lot of law firms, either because of the COVID-19 pandemic, were unwilling to take the case. Also because of the short notice. This was a 2-day trial that essentially the trial counsel withdrew and there was a little more than 30 days to obtain new counsel. A lot of the firms didn't want to take on a case on such short notice.
So that evidence was presented in a motion for a hearing, the affidavit attached to that. Was there anything that your clients did before the trial, bringing it to the court's attention? Hey, I'm having a hard time finding a new attorney because of COVID and everything else. Was there any motion to continue the trial? Was anything brought to the trial court's attention before the trial?
Well, the appellants didn't think the trial was going forward. In that the same affidavit that was attached to the motion for hearing, the appellant Miguel Vidal did reach out to the court to see and was informed that the court was closed.
Well, he did show up by Zoom for the trial.
Well, yes, ma'am, because of yes, Your Honor, because of the email that he got at 6:45 the night before the trial that the trial was actually going forward. So he showed up, but he was under the impression because of the governor's moratorium that stopped foreclosures from proceeding, because the fact the courthouse was closed, the trial was not going forward. Thank you. So I'd like to address the due process issue with the May 7th trial first. As previously discussed, on March 3rd, the trial court entered an order setting a 2-day trial, set a trial on all 4 counts to be tried on May 7th. Following the entry of that order for non-jury trial, the COVID-19 pandemic struck this country, resulting in Governor DeSantis issuing emergency orders, one of which being that there was a foreclosure moratorium, that the courts were not to proceed with foreclosures. As the court's aware, counts 3 and 4 of this action were foreclosure counts. Further,
Your position that all foreclosure and eviction cases that were ongoing had to just come to a halt at that point? Or could just a foreclosure sale or the actual writ of possession not be issued? What's your position on that? And is there any case law to back that up?
So there is case law that says that the governor had authority to issue the executive orders that he did. And the executive order is pretty clear. It suspended all causes of action for foreclosure.
Case law out of the First District Court of Appeal?
Yes, Your Honor.
Wondered.
So, Your Honor, I believe the governor had authority to issue those orders, and the face of the order was clear that this cause of action for foreclosure was suspended. I believe that included proceeding with a trial, proceeding with a sale, really anything to do with foreclosure action, which was really the heart of this issue.
But in this case, the sale did not happen. I don't know if it's happened, but it's not in the record that it has happened.
The sale has not
Correct.
occurred
Okay.
yet.
So what's the prejudice? I know that there was a judgment entered, but
Well, the
if there
prejudice.
was a violation, what would be the prejudice?
Well, the property is owned by LTCS trust, and they had no notice that the trial was actually going to proceed. And so there was, while I know they had retained counsel, all the facts that were out there, the moratorium, the closure of the courthouse, no new notice that the trial was going to proceed.
Well, I was referring to the sale. If a sale has not happened, then what would be the prejudice if there was a violation of the governor's executive order?
Well, they didn't have an opportunity to defend themselves at trial. They not only changed, I mean, it's akin to changing, they didn't just change the location of the trial, they changed the location and locked the door. Without that Zoom hearing link, they couldn't appear and ask the court for additional time. And I understand they had to be represented by counsel, but they couldn't even show up and have the court tell them, you're not allowed to speak here today. They simply had no opportunity to make any requests of the court.
They could have filed a motion asking for additional time to secure counsel. They didn't do that, did they?
They did not file a motion, no.
That had nothing to do with COVID. COVID didn't prevent them from doing that, right?
Well, as in the affidavit that was filed by Miguel Vidal,
Did COVID stop them from filing a motion to ask for additional time to get counsel?
well, they attempted to hire,
Wouldn't that have been, the perfect way to go about it, is that, judge, you gave us 30 days to get a new lawyer, but because of COVID, we're unable to accomplish that within that time frame. We're requesting an additional X number of days.
they could have filed a motion to continue. I think that would have been one way to address the issue. As stated in the affidavit by Miguel Vidal, they did make an effort to hire new counsel. I believe that if they had filed a motion to continue, as argued by Appley's counsel at the trial, that the court should not consider anything from the trust or the LLC because they were required to have counsel. So they would have needed to obtain counsel first to be able to properly file that motion. And as stated in the affidavit, they attempted to hire counsel but were unsuccessful. And I would just impress upon the court, there was a 1-month window, and during this period of time, it's not as if today where everyone's used to appearing by Zoom, Microsoft Teams. That was unheard of at the time. You had telephonic hearings, rarely, maybe outside of some bankruptcy hearings, did you have video hearings. So in this a period of time where you have non-attorneys, individuals, corporate representatives that are thrust into, an unprecedented setting for court proceedings, it's easy to play Monday morning quarterback and say they could have filed a motion to continue, but I think that the world at that point was in a very different state than we are now, in a very unprecedented state of upheaval. Moving on.
Well, before you do, you said the court never gave them notice that the trial was going to continue. or was going to be continue on the originally set date. I understand there are unusual circumstances going on at the time, but the court usually required to give notice that, hey, by the way, the trial is going to go forward? Trial courts don't do that, do they?
Well,
They got notice that there was a trial, and the court would give notice if it got canceled, but do you have to give notice that, hey, we're still going forward?
I think if the court changes the location of the trial, and I would quote directly from Judge Mosley from the trial transcript in 434 in the record, I'm a little concerned about the notice issue. When this was originally set for trial months ago, it was set for the courthouse, and no subsequent notice was sent out saying it was going to be conducted by Zoom. And obviously, I knew you provided me Mr. Vidal's email address, and he's addressing Appellee's counsel at this point, so that's how he obviously is aware. But I have a little concern about if there was a corporate representative, if the corporation is not here, how would they have even known to be here?
Well, Mr. Vidal was the corporate representative, not for the trust, but for the LLC, right? So on the order allowing counsel to withdraw, it said further notices are to go to the corporation to Mr. Vidal.
Mr. Vidal was the corporate rep for...
Okay, so the corporation then conceivably got notice.
But the trust did not, and what's critical is the trust is the party that actually owns the property, which was subject to the count 3 and 4, the foreclosure counts. The party that owned the property was not noticed that the location was going to be changed. And it's not simply you could show up at the courthouse and ask at the front desk, where's Judge Mosley's, the trial for Judge Mosley taking place today? Even if they were aware it was via Zoom, without that link, it's as if they changed the courtroom and locked the door. You can't get in to appear at that trial without that link. And it was sent to 3 parties, Appellee's counsel, Appellee's witness, and Miguel Vidal, and nobody else. It simply could not appear, could not have any meaningful opportunity to present testimony, to even ask the court for a continuance. Whether the court would have granted that, we don't know, because they never had an opportunity to appear and represent. They had trouble finding counsel. I'd further point to the court that the trustee for the LTCS trust is an attorney. Appellee's counsel, the court was well aware of the fact that the trustee was an attorney. They noticed the final judgment was sent to that party. They made no attempt to email the Zoom link to the attorney that represents the trust or the trustee, in further evidence of lack of due process. As stated, the governor's executive order placing a moratorium on foreclosures prevented the trial court from proceeding that day as well. This was not addressed at the start of the trial, but there was a moratorium in place that suspended the cause of action for foreclosures. As such, the trial court should not have proceeded with the trial. Excuse me. The final judgments that were entered that day, as the counts 1, 3, and 4, should be vacated, as they were entered in disregard for the governor's executive order and based on a clear lack of due process provided to the appellants, LTCS Trust and Legends Golf Orlando.
Does it change anything that the court said if you don't retain counsel within 30 days, the court can enter a default against you at any time without further notice? Does that matter at all?
Well, first I would suggest that the court didn't make any findings. While that was brought up, if you review the trial transcript, yes, that was brought up by Appellee's counsel that was in the order. But the court didn't make any ruling or findings that day at the trial that that's what he was doing. Secondly, Your Honor, striking pleadings, entering a default judgment is an extreme remedy. I think if you look at this, there was a 30-day period of time to hire new counsel in light of the pandemic and things that were going on. I doubt that would, on review, I don't know that would have held up if the judge had done that, but that's not what the judge did. The judge decided to proceed with the trial at Appellee's request, despite the trial judge noting there was a clear lack of notice. From review of the transcript, it appears that almost in a punitive way, based on the Miguel Vidal's failure to appear at a deposition, really everything was addressed but the lack of notice once it was raised by the trial. Trial court proceeds. Ultimately, 3 judgments are entered at the conclusion of that day. The counts 3 and 4, the foreclosure judgments against LTCS Trust, the party that owned the property, who had no notice that the trial was actually proceeding. Briefly just addressing the judgment that was entered as to count 2, the eviction. It's clear from that notice that the parties were not provided adequate notice that essentially what was going to occur that day was a de facto trial.
The hearing on that happened, it was almost 2 months after the notice was filed and served, correct? And your clients did have counsel at that time?
They did have counsel. There was no...
They may not have clarified what the hearing was going to be on if they needed to in those 2 months?
They could have reached out, but I would argue that it's the moving party's job or responsibility to put the other side on notice. We have a notice of hearing there that simply says evidentiary hearing, count 2. There's no pending motion directed at count 2. As stated by appellee, they weren't moving under any sort of summary proceedings rules. They essentially set their own trial after the court had already entered an order setting a trial. Trial order required exchange of witness exhibits list, trial memorandums. Discovery had not been closed at that point, but yet the court allowed what essentially was a plaintiff notice trial to proceed there in October, and without adequate notice, without really any meaningful opportunity for the appellants to be prepared and to put on evidence in support or against the eviction.
We have no transcript of that hearing either, so we don't know what happened at that hearing.
That is true. I would also argue that just a cursory review of what's titled a lease that's attached to the amended complaint shows that it's a finance agreement to purchase property. The monthly rent payments, if you want to call them that, are based on interest rate based on the principal amount, which is to be paid at the end of the term, at which time the Legends Golf Orlando LLC and Miguel Vidal would take ownership of the golf course. And so really the proper remedy there would be to have to foreclose that and not to bring an action to evict and for breach of lease, but to actually bring a foreclosure action.
You're into your rebuttal time. You can continue if you'd like, but you've got about 3.5 minutes left.
I'll reserve. Thank you.
Good morning, may it please the court.
Good morning.
Counsel. Good morning, my name is Lindsay Holt from the law firm of Crawford Monica Holt. I represent the appellees LGCC Holdings LLC, David T. Nominick and Laurel Meckel. In this action, they were the plaintiffs in the lower tribunal. As a threshold issue, I will point out that there is a discrepancy between the parties in this action as to what is the appropriate standard of review to be applied in this case. You've seen in the briefing that the appellants argue that it should be a de novo review. The appellees argue that the appropriate standard would be fundamental error, and that is based on the premise that the appellants here have simply refused to acknowledge the procedural history of this case. As the court can glean from the record here, at no time during any of the hearings, including the May trial, and not even in the motion for rehearing, which is in the record at 596 to 603, was due process objection even raised. As counsel did state in his argument, the court itself raised a question at the beginning of the trial as to whether the corporate entities had notice.
Doesn't just an argument made as to notice really raise a due process? You know, they argued we didn't get sufficient notice. Isn't that a due process argument?
I could certainly see the court's point of view, but my position is that it actually was not raised at all by Mr. Vidal at the trial. It wasn't raised by any of the lower tribunal defendants.
They weren't there for the trial.
Mr. Vidal was, and he didn't raise it. The court asked the question of myself as counsel whether notice was given to the corporate entities.
How much of the trust to the trust?
The trust is a corporate entity. It's a corporate trust. It's similar that this court did in the interlocutory appeal case at 5D20-0082. This court in April of 2020, just like the lower court, did an order requiring the LT SUS Trust corporate entity, as well as Legends Golf Orlando, to retain counsel to appear within a fixed time. That didn't happen in front of this court, so on May 3rd, 2020, this court dismissed the appeal as to count 2 as regarding the eviction. So the same thing happened in this case. There was, prior to trial, at least 30 days, an order entered by the court which reminded of the trial date and admonished the corporate entity defendants to retain counsel by a fixed date. That came and went.
Well, the court also ordered Mr. Vidal to retain counsel within that same time frame. That was improper, wasn't it?
That doesn't comport with my memory of the order. I believe it was just to the corporate entities, but assuming that Your Honor is correct, and I will assume that you're correct, Mr. Vidal did appear pro se, and the appellees made no objection to him proceeding pro se, and in fact, he did participate in the trial. As stated by the 5th DCA in a 2002 case of Anderson versus School Board of Seminole County, that site is 830 Southern 2nd 952, when due process objections are not presented during a hearing, any objections must be deemed to have been waived, precluding the right to raise those issues for the first time on appeal. The Dumerlis versus Wilmington case cited in the answer brief goes on to say that in such an instant, the appellate court reviews the trial court decision for fundamental error. But even assuming arguendo, if this court was to look under the broader periscope of a de novo review, a due process violation is simply not in this record. I'll first want to touch on something that was raised both in argument and in both of the briefs filed by the appellants in this case, and that's this infusion of a new defense that, hey, this wasn't really a lease or proper note in foreclosure. This was a financing agreement, and the court should have looked at it in that way and that way only. That was a defense that was not raised in the lower court. In the record at 173 to 179 is an answer and affirmative defenses, and that issue simply was never raised.
Well, it was raised briefly in the motion for rehearing. I think that was the first time.
Correct, Your Honor. It was raised certainly in the motion for rehearing as an after the fact. And similar to my argument today, the appellees raised the fact that that was never raised, and it should be deemed waived based on replete case law that says as such. So as far as the financing argument, we would argue that that's simply a red herring and that this court is limited in its scope and cannot consider that argument.
Well, but wasn't that in the context of whether they had a meritorious defense?
The context of whether it was...
Financing agreement.
That was never raised as a defense at all in this action, nor were, because of that, the appellees were not even...
Isn't it raised in the context, though, of, you have to show excusable neglect, meritorious defense? Was that the context in which it was raised?
If it was excusable neglect as to why the parties didn't appear, I don't think it marries well with being akin to an affirmative defense as to the merits of this whole case. So again, I believe that should be set aside and not considered by this court. So the only real issue here is whether the defendants below were afforded due process as to the eviction judgment, I'll call it, and the foreclosure and damage judgments. Hearkening back to that.
Entry of a default?
I'm sorry, Your Honor?
Did you ever move for entry of a default or a default judgment?
We did not. We decided to move forward in the action. And at the trial, of course, the corporate entities did not present themselves. We went forward and presented evidence on all of those matters, including damage, so that the court could make a just and sound finding regarding the damage amount.
But there never was a default entered, there never was a striking of the pleadings or a striking of the answers or anything else?
That is correct, Your Honor. I want to hearken back to that Anderson versus School Board of Seminole County case. That was a 5th DCA case. Again, this court should dispense of the due process violation arguments because they were never raised by the defendants below. For an issue to be preserved on appeal, it has to be presented to be preserved. That's the Hadj-Mack versus Spencer case, a 50 CA case that is cited in the answer brief. In that case, this court dispensed of an appellant's due process argument, as the appellant both participated in the lower court hearing, just as Mr. Vidal did in this action, and it failed to raise due process objections at the hearing. Again, akin to the facts in this matter. Procedural due process requires fair notice and an opportunity to be heard. That's the Borden 50 CA case cited in the answer brief. Borden goes on to say, unlike some legal rules, it is not a technical concept with a fixed content unrelated to time, place, and circumstances. Instead, due process is flexible and calls for procedural protection as the situation demands. As further stated by the 50 CA in the Carillon Community Residential case, 45 Southern 3rd 7, due process only requires the proceedings to be essentially fair. So as to count 2, that eviction judgment, clearly, at a minimum, it was essentially fair. In fact, the counsels for both parties had coordinated to schedule the date of that hearing. It was noticed as an evidentiary hearing. The fact that they acknowledged having notice, the parties were represented by counsel at the hearing that presented arguments. There's certainly no merit to this issue now on appeal.
Is there a difference between an evidentiary hearing and a trial? Wouldn't there be disclosure of exhibits, disclosure of witnesses?
There was not, Your Honor, and our position is...
Really, was it a trial?
I believe it was an evidentiary hearing per 83.20. This was for the writ of possession only. That statute even affords the court to summarily enter a writ of possession when there's been a default in payment.
Damages awarded?
Damages were not awarded. Damages for breach of the lease were awarded at the trial in May, and that is count 1 of the amended complaint. What resulted out of count 2 was simply the writ of possession to remove the tenants from the commercial property. For these same reasons, the argument must fail as to counts 1, breach of lease, counts 3, and counts 4, which are the foreclosure and action on the notes counts. As stated in the initial brief, by an order dated March 3rd, these claims were set for a non-jury trial on May 7th, 2020. The appellants had over 2 months to prepare. Preceding this in the fall was a pre-trial order fixing dates. In fact, in December of 2019, both parties filed pre-trial memorandums with the court. A month after the case was set for trial, but a month before commencement of the trial, the appellant's attorney withdrew from the case. By the order that's found in the record at pages 402 to 404, the trial court specifically required the 2 corporate defendants to file a notice of appearance of new counsel by May 3rd, 2020. Of course, despite that admonition, that never happened. The parties, when they had counsel leading up to trial, had already exchanged witness lists, exhibit lists, and hard copies of exhibits. This takes us to the cusp and the eve of the trial. Certainly, Mr. Vidal had notice of the Zoom trial. His previous counsel had provided his email address to receive as such. The Zoom notice went out to counsel for the appellees, the pro se individual, and a fact witness that was appearing at the trial. Not only were the...
And who prepared those notices?
They actually came directly from Judge Mosley's office. It was sent via email with the link and instructions for how to be on the Zoom trial.
And did your office forward anything on?
We didn't have a forwarding address beyond the address for Mr. Vidal. Of course, as this court noted in its comments during counsel's argument, Mr. Vidal is in fact the only corporate representative of Legends Golf Orlando LLC. Mr. Warda, as a trustee of the corporate trust, had never provided an email address, and one was not provided by previous counsel. Just as a personal note, I was not aware until today that Mr. Warda is an attorney.
Would the judge normally give notice to one side's witness of a hearing time? How did the judge get the witness's email address?
I'm not certain, except that it is unusual times, I believe, and certainly there's nothing in the record that supports this. My recollection is that the judge's JA contacted my office to ask for all email addresses for parties that might be attending the trial. So I believe that was supplied by my office. Your Honors, not only were the corporate entities required to obtain new counsel, they were required to file that notice of appearance, which they'd never done. Had the corporate entities filed a notice of appearance, their new counsel would have been aware of the Zoom instructions and been aware of the trial. Again, as I previously mentioned, this same thing happened by failure to file a notice of appearance before this court in case 5D20-82, and that case was dismissed. The facts of this instant case squarely fit with that Parrot Cove Marina case, which I argued on behalf of the lower court plaintiffs at the trial. In Parrot Cove, the court found that in denying an asserted due process argument that had the entity retained counsel within the requisite period of time, its new counsel would have become aware of the trial and the entity could have been represented. Here, that simply did not happen. The appellants completely ignored the court's order. They ignored the Fifth DCA's order in the interlocutory appeal and instead just summarily assert that this Zoom trial invitation is a hypothetical error in due process. Contrary to these contentions, regardless of the fact that the trial proceeded by Zoom and it was given the day before, judgment would have been entered anyways because those parties were not represented. Again, as it relates to Mr. Vidal, the individual pro se defendant, he acknowledged receipt of the notice of trial over 2 months prior. He, in fact, was at the trial. He offered testimony and he cross-examined witnesses. Based on these undisputed facts, the appellants were not deprived of due process in either of the proceedings.
So going off of something you just said, if all the parties had shown up without counsel, would a default have properly just been entered right at that time because the LLCs did not have counsel, or would the trial court have needed to go through the elements to enter a default in any other circumstance? What would have properly happened?
I would assume that the trial court might have exercised its discretion to allow the trial to proceed forward, or had, as Judge Cohen asked in counsel's prior argument, they could have lodged a motion to continue the trial, but that was never done.
Could a default just have been entered? Like the trial judge just said, I'm sorry, I know you're all here on Zoom, but I'm entering a default because you don't have counsel.
I do believe that a default could have been entered, and in fact, that was already previously ordered in the order that when the counsel withdrew, which required those parties to obtain new counsel, it specifically stated that default judgment could be entered if they did not comply with the terms of the order, which the parties did not.
If we were to find a violation of due process, what prejudice is there to you?
There's great prejudice to the appellees if what their appellants are asking is for a remand for a complete new trial. Here we stand today, nearly 2.5 years after the commencement of the action, which was pre-COVID. My clients have exerted great efforts and expense at getting this case to where it is today. It will be nearly 3 years if we get to even proceed with the foreclosure.
Part of this is because you were pushing this so hard.
Counsel, Your Honor, I respectfully state that I was zealously representing my clients who had not received one payment under the lease or the foreclosure, nor to this day have they received the same. The case, again, resulted in 2018 pre-litigation efforts. It was filed in early 2019. Really in the spirit of the new Supreme Court ruling on differentiated civil cases, the trial happened within a year. In the spirit or in direct compliance with the governor's COVID order, to date, there has not been a foreclosure sale that has occurred. Counsel acknowledged at the trial that there was an executive order and acquiesced that a foreclosure sale could not happen until that moratorium has been lifted. It's now come and gone. To date, my clients are out this egregious damage amount, which they've received nothing from the defendants directly. And so to have a trial anew, to take this back on remand and allow this Monday morning quarterbacking, as counsel called it, would be extremely prejudicial to my clients. And just walking this forward, which marries well into this tipsy coachman last argument that was made in the answer brief. If you think this forward and it goes back on remand, if there was a mistake which had happened, the court got it right for the wrong reasons. These judgments are sound and should be upheld. The record testimony shows at many different instances that the defendants acknowledged that this was a valid agreement, acknowledged that they were in default. There's competent, substantial evidence supporting not only these damages amount, but there was additional damage evidence that the plaintiffs in the lower court did not seek.
The evidence only came from one side.
Well, respectfully, Your Honor, Mr. Vidal was present and did speak regarding the damages and have an opportunity to present counter-defense at the trial. In fact, he gave somewhat lengthy narrative testimony and cross-examination to that effect. So based on that doctrine, it seems nonsensical to remand. It would be a great prejudice to the appellees when the record evidence already admits valid agreements and it admits defaults. Again, to the state, there has been no foreclosure sale. Clearly, as the pro se individual had noticed and in fact participated in the trial, there was no due process violation. There was no due process violation as to the corporate entities based on that Parrott Cove case and other sound case law, and therefore we would respectfully ask this court to affirm the judgments of the lower court.
Is the golf course still operating?
The golf course ended up not being in operational condition because it was let go for so long. My clients sold it for a loss.
Right.
Thank you, Your Honors.
Thank you. All right, 3 minutes, 22 seconds.
Thank you. One thing that is missing from the answer brief from the appellees, and when questioned today by the panel, the appellees counsel couldn't provide any explanation, is the issue that there was no notice to the trust. Whether Mr. Vidal was there in his capacity individually or and also as a corporate representative of Legends Golf Orlando LLC, I think is a disputed fact there. But there is no dispute that LTSC Trust did not get notice that the trial was proceeding via Zoom. There was no findings by the court that a default should be entered. I think without an appropriate finding that there was valid or just cause to enter a default, the court couldn't have entered a default and struck the pleadings of the defendants, the appellants. Counsel keeps citing to the Parrott Cove case. I would state that that's really inapplicable here. The facts of that case are there was a trial order that said you had to go to check in with the court to find out when you're going to go on this 2-week trial docket. And the defendants in that case failed to check in with the court and did not appear when the date their trial occurred. But on that order, it provided the instructions: call this number. You can to find out when your trial is going to go. If we look back at the original trial order, the amended trial order, any of the notices provided to the court outside of the May 6th, 6:45 p.m. email, LTCS Trust, Legends Golf Orlando LLC could not have ascertained how to know when the trial was going to proceed or in what manner via Zoom.
What about a phone call to the judge's office? They couldn't have done that? They're given a date of trial. They're given notice of that trial date, and that date is approaching, and yet, COVID is hitting, and so things are changing. What about making a phone call
Well,
to the judge's office?
in the
and
affidavit of...
saying, is this trial, we're in the middle of a pandemic, although I guess depending upon who you are, that's a disputed fact, but, is this trial still going to go on?
In the affidavit of Miguel Vidal that was filed in support of the motion for rehearing, he contacted the court and was informed that the courthouse was closed. Could he have called the judicial assistant? Yes, but I think it's reasonable for the assumption that the courthouse is closed, the governor moratorium is in place. The fact that they didn't call to find out if the trial was proceeding, I think they had a reasonable decision that the trial or came to that assumption the trial was not going to proceed based on all these factors that were out there, and it wasn't as if there was no effort to go see if the trial was going to go forward. In the affidavit of Miguel Vidal, they contacted the court, was informed by the court services the court was closed.
I don't know who they contacted. It's unclear as to who they contacted.
Once again, there is nothing in the record that supports the position that LTCS Trust received notice. The idea that they waived an objection.
They received notice of the trial. The only question is that they didn't receive notice that the trial was going to be conducted by Zoom.
Your Honor, I'd say that's akin to if this morning this oral argument was moved to the City Island Courthouse and no one provided me any notice of that, and if I showed up here and the courthouse door is locked, how would I know the trial had been moved to City Island Courthouse? And that's what was going on at the Lake County Courthouse.
Is there anything in the record that shows that the corporation or the trust appeared at the courthouse on May 7th? Anybody on behalf of them?
They did not. They did not appear, as it stated in the affidavit from Miguel Vidal, that the trial had been, that he had contacted the courthouse and that the courthouse was closed. I have not spoke with the attorney Mark Warda, who is the trustee, as to any additional efforts he made, but clearly the appellees in this case were on notice that Mark Warda was the trustee. On the final judgment, the final judgment lists Mark Warda, sent the final judgment to his address, so it wasn't as if there was no ability to contact him, and clear from the record there was no attempt made to contact him and put the trust on notice the trial was proceeding.
All right, any further questions from the panel? All right, thank you, counsel. Thank you very much.